No harm, no foul. The state can't tell you why he's here, but the state tells you that the process is sufficient. Frankly, Your Honor, the Supreme Court disagrees. We're going to have oral argument on June 15th on the process that the 8th Judicial District Court has put in place to not notify and not place on calendar when the electronic monitoring protocols are allegedly violated. So the state is correct. What happens now is when someone's taken in on EMP, what we get is we get a note with hearsay, with unproven hearsay in it from the house arrest officer. And more often than not, when we try and schedule a hearing, the house arrest officer doesn't come. And when they do come, in the few times that I have had evidentiary hearings on these matters, many of the assumptions or the averments put forward in those house arrest or electronic monitoring protocol notes are proven to be demonstrably false. But because the requirements are so broad, the court usually finds some violation even when putting him back in custody. This case is clear with Mr. was placed on low-level electronic monitoring. There was no basis to return him into custody in this case. The only basis for returning him into custody was in the Justice Court case, which was to be dismissed pursuant to these negotiations because he was on a different category of electronic monitoring. Thus, despite the fact that he called his house arrest supervisor, left him a message, let him know that he had a brother's party that he wanted to go to, the house arrest officer deemed that as being an unauthorized stay away from home and took him into custody for the Justice Court case. But again, here, Your Honor, the state sidesteps the issue, but let's be very clear. There is zero violation for him to be in custody. And this is the only case that has been holding Mr. since last week because of how house arrest processes these electronic monitoring violations. They schedule no hearings. They file no motion. The state is not required to file any motion like they would have been in the good old days before when we had bail, and that was the only condition of release. If the state wanted to take away somebody's bail, they were required to file a motion to forfeit that bail and tell the court precisely why. If the person picked up a new charge, then they typically be in custody on that new charge. But because of the wonders of the electronic monitoring program and its complete lack of oversight, what we have is a situation that's been bred where all the court gets is this hearsay memorandum. No hearing is scheduled, no motions are filed until a zealous advocate for the defense does so. So, Your Honor, let's be very clear about what's happening here. In the case that's before the court today, there is zero violation that occurred to the electronic monitoring protocols because on the level that this court was placing him on, there were no violations. So he shouldn't even be in custody. The only reason that he's in custody, and I was forced to file this motion, is because the court has vested unilateral authority in electronic monitoring personnel to put somebody in custody and then not do anything about it until their attorney does something about it. Well, I did something about it last week in Justice Court. Justice Court has a different process. Whenever somebody's placed in custody for purported violations of the electronic monitoring, the Justice Court themselves places that person on calendar. That's what the district courts fail to do. They think that this note is sufficient. I suppose, Your Honor, in less than a month, we'll start that process or we'll complete the oral argumentation process to figure out if that really is sufficient. Obviously, my position is it's not. My position is that other courts do more, that the municipal court does more, that the justice court does more when dealing with infractions, and that the district court should be doing more. But specifically on this case at hand, Your Honor, not dealing with the process, we have Mr. who is in custody and he shouldn't be. He should be released on low-level electronic monitoring, but unfortunately, electronic monitoring won't do that until you specifically command them to do so again. Now, to deal with the state's natural argument, which I expected they would make, which is why I asked for him to be released so he could put his affairs in order, Your Honor. Mr. has been taking classes in order to complete a program so that when he gets out of prison, Your Honor, because this is a stipulated sentence, that he will be able to go directly to work. But he needs to finish that program beforehand. So that's why we asked for the continuance. That's why we're asking for a continuance here. How much longer is it, Len?
I have one more month.
So we are at the finish line, Your Honor, and but for attending a birthday party for which he asked permission, and even the Justice of the Peace acknowledged that had this gone to the court, instead of the tender mercies of the electronic monitoring personnel, the court would have had no problem with him attending his brother's birthday party. He committed no new crimes at all. And he was in contact with electronic monitoring personnel to the extent that they would allow him to be. The Justice Court dealt with that violation. They've released him from electronic monitoring entirely, Your Honor. The only case holding him is this one, for which there is no violation. And, Your Honor, I would ask the court, just in a theoretical sense, holding someone without bail, without cause, without charge, isn't that the penultimate due process violation when the person doing it isn't even required to file so much as a motion? That's the question being put to the Nevada Supreme Court. And I put that question to you. But more than that, Your Honor, I'm asking for you to place him back out on electronic monitoring at the original level in which he was originally placed by this court.
All right.